Hello, I'm attorney Vince Davis. Today we're doing a deep dive into the massive transformation of California's landlord-tenant laws from 2024 through 2026. These updates reflect a major legislative push toward transparency, credit inclusion, and homelessness prevention. It's critical that you understand how these impact your rights. Senate Bill 567, known as the Homelessness Prevention Act, went into effect in early 2024 to strengthen the Tenant Protection Act of 2019. Under this law, if a landlord or their relative moves into a unit, they must now occupy it within 90 days and reside there for at least 12 continuous months. For no-fault evictions based on remodels, the work must now require a permit and necessitate the tenant's absence for at least 30 days. No more minor repairs as an excuse. Assembly Bill 12 is another game changer. As of July 2024, security deposits are capped at just 1 month's rent for both furnished and unfurnished units. Small landlords owning no more than 2 properties with 4 or fewer units are generally exempt, but military tenants are always protected by the 1-month cap. If you're in a deposit dispute, Senate Bill 71 has increased the small claims court limit for individuals to $12,500. Coming in April 2025, Assembly Bill 2747 requires landlords of 16 or more units to offer tenants the option to have positive rent payments reported to credit bureaus. This allows renters to build their credit scores through their largest monthly expense for a service fee capped at just $10 a month. Assembly Bill 2801 mandates a photographic paper trail for deposit deductions. Landlords must take photos of the unit within a reasonable time after you move out. For leases starting July 2025, landlords must also take move-in photographs to establish a baseline of the unit's condition. The law also explicitly prohibits charging for professional carpet cleaning unless it is reasonably necessary to return the unit to its original condition. Starting in 2026, California expands habitability standards with Assembly Bill 628. All leases must include a working stove and refrigerator. Landlords will be responsible for the repair and maintenance of these appliances. They are now considered essential components of a habitable home. Technological freedom is also arriving with Assembly Bill 1414. Starting in 2026, tenants can opt out of mandatory bulk billing for internet services. If a landlord retaliates or continues to charge for an opted-out service, the law permits you to deduct that cost directly from your rent. Senate Bill 610 clarifies that tenants under mandatory evacuation orders for wildfires or floods do not owe rent for the period they are displaced. Any prepaid rent must be refunded, and landlords must use licensed remediation contractors for cleanup before you are required to resume payments. Finally, Assembly Bill 246 provides a new defense against eviction if your non-payment is caused by federal delays in Social Security benefits. Courts can now stay eviction proceedings for up to 6 months while those essential benefits are being restored to the tenant. These laws represent a profound shift toward protecting the financial stability and dignity of renters across California. Staying informed is your best defense. These laws are complex, and knowing your specific rights can make all the difference in a dispute. If you're facing an issue with your landlord or need guidance on these new regulations, our team is here to help. Call us now at 888-888-6582. I'm Vince Davis, and we are all in this together.